Hello. Today I'll be talking to you about terms of trade. My name is Doug Brown and I'm a commercial lawyer at Folbigg. What are terms of trade? Terms of trade are essential for any business which supplies goods or services. Terms of trade are the standard terms and conditions a business uses when dealing with its customers. They could be the fine print or the standard terms and conditions you click accept on when you buy goods or services online. Why are terms of trade important? Well, under terms of trade, a business owner can include appropriate disclaimers to exclude or limit their liability on such matters as implied terms, warranties and conditions, or types of losses suffered by consumers, such as consequential loss, or a business owner's liability to repair or replace goods, resupply services, or refund the purchase price. In terms of trade, you can also specify how long quotes last for, when a contract is entered into between the parties, and company policies on such things as return of goods, cancellations and refunds. Terms of trade can also set up payment and credit terms such as default interest, your right to repossess goods, and where credit is involved, you can also include a clause allowing you to register your security interest on the PPSR. In your terms of trade, you can also specify what a breach of contract is and under what circumstances you can terminate or suspend your suppliers. You can limit your liability for acts of God, such as war or environmental disaster, and the parties can also agree on a dispute resolution mechanism, such as mediation. Why do you need a lawyer to draft your terms of trade? Can't you just do it yourself? Well, there are certain statutory requirements under the Australian consumer law. Under the ACL, consumer guarantees and mandatory text cannot be excluded, and there is a prohibition on unfair contract terms, so your terms of trade cannot contradict the unfair contract terms in the ACL. You should have an experienced lawyer draft your disclaimer and exclusion clauses, as poorly drafted clauses may be ineffective and expose you to even greater liability and risk. What else do you need to know? Well, terms of trade are not the be-all and end-all. They are only binding on parties to the agreement, such as the supplier and the consumer, so they will not limit your liability to third parties for loss or damage. Businesses are encouraged to obtain appropriate insurance policies in any case. Terms of trade will also not limit or restrict your other obligations at law, such as a director's non-delegable director's duties under the Corporations Act. Parties are advised to seek legal advice whenever in doubt. Folbigg's commercial lawyers are experts in preparing and drafting terms of trade. We've helped many businesses across a variety of industries to protect and assert their legal rights and safeguard their interests. Please contact us today.